Hi, my name is Charles Massimo, President of CJM Fiscal Management. One of our goals at CJM is to help our corporate clients provide one of the most cost-effective and successful retirement plans available. And today we'd like to talk specifically about 403B plans and the many changes that have occurred. And to help us with that is Rick Knipe, an IRS enrolled agent, as well as being principal of Millennium Advisors. Millennium is one of the largest independent fiduciaries in the country. Welcome, Rick.
Thank you, Charlie.
Rick, can you first tell us a little bit about your role as an independent fiduciary?
Yes, it's basically we step into the shoes of the chief financial officer, the CEO, the HR director to try to become the vice president of the retirement plan. Basically make sure that the day-to-day operations comply with the governing plan documents and in compliance with the overall IRS DOL regs.
Great. And a few years ago, I believe it was 2009, a major change took place impacting just about every 403B plan in the country. Can you talk a little bit about that change?
That's right. The regulations used to exclude the 403B tax sheltered annuity from Employee Retirement Income Security Act of 1974 for many decades. Unfortunately, the plans became prey to the individual insurance agents that were out on the street, and they had no real governance over the plan. ERISA is not necessarily bad. It allows the plan sponsor to utilize governing regulations and protect the participants, the employees. But it did become necessary to file annual reports, look at testing, and other things to be in compliance in 2009.
Okay, so prior to 2009, the majority of 403B plans did not have to comply with ERISA?
That's right. They didn't have to report to the government annually. They didn't have to perform testing, and they were basically individual accounts for everyone at the hospital or at the education.
So if I'm a trustee, if I run a 403B plan, how do I know if I have to be ERISA compliant now?
That's the hardest question. The government put out governing regs on testing whether you needed to report or not. And basically, if you have any discretion over the vendor, any discretion over the benefits, the rights, and the features that you have inside the plan, then you take over as an ERISA fiduciary under the regulations that retirement account. So you basically, if you tell anybody what to do, whether it's from a contribution, from allowing someone to come into the teacher's lounge, you put that plan under ERISA.
Really? So that discrimination is pretty broad.
It is. It's not bad. A lot of plans are being criticized for not going under ERISA when required. But ERISA preempts state law. So depending upon litigation in the state, it could be good to take the plan outside of the state and govern under ERISA, protecting the plan fiduciaries from their personal assets being potentially attached in a state litigation issue.
Okay. So I understand the importance or the value of maybe actually going under ERISA, but talk about some of the issues of being non-compliant for a 403B plan.
Okay, the areas that typically you have difficulty with is with a conflict of interest, where you allow in the teacher's lounge a Jackson National Life, a Travelers, a Nationwide insurance salesman, and they treat each of the individuals differently. They basically discriminate. Maybe the nurse has a 12-year surrender, but the doctor has a 4-year surrender. So your issues relate to conflicts within the plan itself. Those cause a 15% excise tax under the IRS, a 20% under the Department of Labor, and then if not corrected timely, a 100% compulsory tax added onto those.
Wow. And when you say those taxes, the taxes are based off of what?
The plan's assets that are affected by the party in interest. So if you have basically, say, all of the teachers are accessing an individual who's conflicted, then all of those teachers' account balances are subject to the PT.
Where does that money come from for the not-for-profit to pay those taxes?
Well, that's the trouble. If the IRS, typically they'll negotiate, and the Department of Labor will negotiate, but the party in interest that causes the transaction is who they should go after first. And when I say go after, the CEO, CFO should send the IRS form 5330 to them and ask them to pay that. But of course, typically there are carve-out indemnifications in contracts that say we're not responsible at the financial services company for anything that goes wrong under ERISA they are, and they typically have some information that's in their files to protect them from the participants signing off and waiving rights.
Right.
So that can be hard.
You know, many of the 403B plans that we've been into, they seem to, the majority of them have these very expensive annuity contracts. And many people are under the assumption that's all that's available in a 403B plan. Why are so many of these plans layered with these high expense annuity contracts?
You know, the fixed contracts, the variable contracts are all part of the insurance industry governed by the applicable state that you happen to house your hospital in. And the mutual fund industry never really has penetrated because they've had a lock on that market. So unfortunately, you know, it's governed by the lowest common denominator, and if the hospital is unaware that they could buy a mutual fund without a wrap fee, then they pay the wrap fee.
And in general, what would you say on average to own an annuity contract costs a participant?
A noted attorney, Fred Reich, said that it's typically 1% to 2% more per year than having the actual underlying SEC registered mutual fund. So you could be paying 4%.
4% a year. And how many participants you think are aware that they're paying such high fees?
Well, that's the problem with the rules under putting a 403B in 2009 under ERISA. Now next year, those fees that were never seen paid at the mutual fund level and the insurance separate account level or contract level will become apparent. So they thought everything was free. They're going to find out that free is really expensive.
Mm-hmm.
And when they find out that their free plan really cost them $2,000 per person per year, they may decide to walk into human resources.
Right. And this issue of high fees that are not disclosed, can that potentially be one of those prohibitive transactions you mentioned that would impose a 15% or higher excise tax?
That's right. It's the ERISA says reasonable fees for services rendered. So if instead of $2,000 per person, the 72 million Americans next year, they're going to learn about their fees. They're going to ask, is it always $2,000? Has it been $2,000 per year? Can it be $1,000 per year? And in these lean times, they may complain to the government. If you call the Department of Labor, they will dispatch for one employee's phone call. Used to need 10% of the population. They'll leave with one. And so in 2 weeks, you could call and have HR embroiled in an investigation that you as a former employee found out about your fee in April next year.
Now, wasn't there also another issue about, I heard about $1,000 a day fine for not complying to a certain rule as well?
Very good. Yes, unfortunately, this reporting requirement that ERISA mandated in 2009, when you don't know whether you're under ERISA or not, you don't know that you need to report. And so unfortunately for 09 and 10, and now you're going into 11, you could potentially have a failure to file penalty of $1,100 a day for every day that that return is late. So the 09 return was due July 31st of 2010. This 2010 return was due July 31st of 2011. So you could potentially have 365 days or more on the 09 return that you're late on. So for every day, that's $1,100 a day.
Oh. And so what would you suggest? What are some of the steps? Who should be advising these 403B plans, and what are some of the steps that trustees of these plans can do?
Well, reaching out to individuals that deem themselves experts under ERISA, attorneys, CPAs, other enrolled agents, someone who is unconflicted, someone that's not going to sell them something, to give them unbiased advice is absolutely critical, and it's better sooner than later. If you uncover you have a PT and you fail to act within certain time standards, you can trigger the 100% compulsory tax. So if you have any suspicions that you have issues or concerns from that moment on, seek counsel. And with the new failure to act rules under ERISA, if someone is presented with an issue with their 403B, their 401k plan, they have to act in a reasonably prudent time period. So that was the George versus Kraft lawsuit that came out May 19th in CFO magazine.
Thanks, Rick. That was real important information. And to do our part, we're providing a one-day seminar. We realize that this is very confusing times for 403B plan trustees. And at this seminar, in addition to hearing more from Rick, We're also inviting a very well-known ERISA attorney to talk about the issues many trustees are facing and things they need to do to make sure they're in compliance to avoid many of the issues and taxes that Rick spoke about. On this page, you'll find all the information you need to register for this one-day, very important seminar. And again, I urge you to take us up on the opportunity, and I look forward to seeing you there. Thank you.